It's now back in order. Chair recognizes Mr. Palmer from Alabama for 5 minutes.
I thank the chairman. I want to welcome the whistleblowers and thank you for your courage, but more than that, for your fidelity to your duty to faithfully enforce the laws of the United States. Mr. Shapley, the statute of limitations has run out on a number of possible felony charges for tax years 2014 and 2015. Is that correct?
That's correct.
And there were huge tax liabilities for those tax years, correct?
There were tax liabilities, yes.
But you didn't have access to all of the evidence related to those sources of income, did you?
Based on the limitations placed on us by Delaware U.S. Attorney's Office, that's very likely.
Okay. Well, the Oversight Committee recently reviewed a non-classified document from the FBI called an FD 1023 form, which is a form used by the FBI to memorialize information related to it by a confidential human source. This FD 1023 form was created in June of 2020. This is not a tip sheet. It's not a hotline. It's not a suggestion box. It's a legitimate source used by the FBI, and it was used here. Mr. Shapley, did you ever review the June 2020 FD 1023 form with information about Hunter Biden and President Biden?
No, I did not.
I reviewed the form, and there's startling allegations in it. What would you have done if presented with this piece of evidence regarding this potential stream of income? Would that have constituted an additional area of investigation?
So, since I've never seen the document, I only know what's been reported.
Right.
So, I can say that there were investigative steps that involved President Biden that were not allowed to be taken, and that information like this would have been really helpful to have from investigators, by investigators when we received any pushback, when we were asked to take names out of document requests or search warrants. It would have been nice to have information that showed why, that helped prove why those names needed to be in those requests.
Well, I think it's material to your investigation because it was, after all, other information that led you, related to Hunter Biden's lifestyle, that led you to launch the investigation to begin with. Was there other evidence in this investigation that you were denied access to?
Yes, there was.
Do you want to elaborate on that? So,
one piece was the Hunter Biden laptop. There's a memorandum that I documented contemporaneously in my House Ways and Means Committee testimony that states what Assistant United States Attorney Leslie Wolf told us on that day. I think it was September 3rd of 2020, and that's that they had information from the laptop that they were not providing to the investigators.
Yeah, can I add something on that?
Yes, sir, Mr. Ziegler.
So, when it came to questions, as a part of the investigation, we interviewed a lot of people. And as a part of that investigation, you want to feel free to ask questions. It should be an open environment. I realize that there are some attorney-client privilege information involved in this, but there was an environment when we were interviewing witnesses where you were afraid to ask questions that could lead to the presidential campaign. And this is after the campaign's over. So questions like that, it was restricted, and so things like that we were limited to talking about.
Well, it appears to me that you learned about the FD 1023 form through public domain sources, and I can only imagine how you felt about having been denied another piece of relevant information. And I think it's important that the committee understand that you guys who were trying to do due diligence, who were trying to faithfully execute the laws of the United States, were denied evidence relevant to your investigation. I think the 1023 form is a very important piece, Mr. Chairman. I want to ask Mr. Ziegler, at one point you wanted to move the investigation to the District of Columbia. Is that correct?
From the very onset of the investigation, yes.
Why did you want to move it to D.C.?
So are we referring, there are two different scenarios in where DC is involved. So when we first initiated the investigation, and then when we referred prosecution. So which time period? So as far as venue for the tax case, so venue for this case, we saw that when we did our analysis, that venue was either in California or DC. Well, I guess at the time in the beginning it was DC. So that was where we wanted to start our investigation, was in DC.
But you were told that Attorney Weiss could bring charges anywhere. Was that your understanding?
Okay, so that fast forward to March of 2022, I had a phone call with the prosecutors assigned to the case. They said that our prosecution report went to low-level people at the DC U.S. Attorney's Office. Those low-level people reviewed it, said, hey, we're going to assist you with this. Here's what we're going to do to help you finish the case here in DC. A few days later, I get another phone call, and it's from the same assigned attorney, and they tell me that now that the U.S. attorney has reviewed it, that not only is it a no, but it's a no, you should not work this investigation in the District of Columbia.
Well, Mr. Chairman, it appears to me that Mr. Ziegler was misled, and that his instincts were right, that it should have been moved to the District of Columbia. And again, I want to thank you for your courage and your fidelity to the law. I yield back.
Gentleman yields back.